Please check your phones. I'll do the same.
Commissioner Fielder, can you hear us okay?
Yes, I can. Thank you.
Thank you.
Good morning. This meeting is called to order. For the record, the time is 1:30 p.m. and the date is June 24th, 2025. The commission and staff are appearing from Helena, Montana in the Bollinger Room of the Montana Public Service Commission. I am Brad Molnar. I'm the presiding chairman for this meeting. Please join me in reciting the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with justice for all. For the record, the following commissioners are present. We have with us Commissioner Wellborn, Commissioner Pinocci, myself is already introduced, Commissioner Vukacek, and online we have Commissioner Fielder. Therefore, we have a quorum because we have more than 3 out of 5 commissioners. Does the Public Service Commission welcomes any comment on any item that is on today's agenda or any matter that is within the jurisdiction of the Montana Public Service Commission? Are there any public commenters in the room? Seeing none. Are there any public commenters online? Seeing none. Are there any announcements? Seeing none. We have minutes. Would anybody like to move approval of the minutes?
I shall move.
Commissioner Wellborn has moved approval of the minutes. Is there a second?
I second.
We have approval and a second. Is there any discussion? Seeing none, the minutes are approved. On. Why not? All those in favor of acceptance of the minutes, say aye.
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 Those in opposition, same sign. The ayes have it 5-0. Work session. First work session is revision of internal policy manual, aka IPM, pay schedule to consider updating Appendix 1 pay schedule in IPM pay policy to reflect 2024 market analysis rates. Beth.
Thank you, Mr. President, and good afternoon, commissioners. My name is Alana Lake. I am your executive director here at the agency. I'm here today to bring forward an amendment to the IPM. This is to simply update the market analysis from 2022 to the new rates that will be effective July 1st, 2025. If you look at your handout there, you will see that the old market analysis is listed there. That is what is currently listed in our IPM. And you'll see an updated market analysis that our business manager, Tina Limousin, has very kindly put together for us that lists the new rates as analyzed for the next 2 years. Pending any questions, that is all I have. This will require a vote of the commission as it is an update to the IPM.
Are there any questions from commissioners?
Mr. Chairman, President?
Yes.
Vice President Fielder, question for staff. Alana, this, as I understand it, this appendix, this pay schedule is developed by the Montana State Department of Administration, and then we are adopting the pay schedule that they have already put in place, and we received this draft last summer. Is that correct?
That is correct, Vice President Fielder.
Okay, just clarifying that it's not our own schedule. We are adopting the state pay schedule.
That is correct. Thanks for the clarification.
I have a quick one. This is based on a 2024 market analysis. Is that correct?
That is correct. Mr. President.
Is it a market analysis of the general business climate out there, or is it a market analysis of other state agencies?
That is a great question, Mr. President. If we have our business manager, Tina Limousin, in the room, I'll defer that question to her. She is not in the room, but we can definitely get that answer for you.
Okay. I don't know if it affects the vote a lot, but I've heard a lot of complaints that the reason agencies, including our own, has trouble retaining people as we look at market rates across government, which is not reflective of what a person can make by walking across the street. I was just wondering where this came from.
Mr. President, I believe Tina Limousin may have just walked into the room and she may be able to answer that question for you.
If Tina's limousine looks like that, I think she's here.
And if you wouldn't mind repeating the question for her, Mr. President.
Tina, we're talking about the pay policy to reflect 2024 market analysis rate from the title. Are those market analysis rates across government, or are they across a broader business outlook, private sector?
President Molnar, thank you for the question. The market analysis is conducted off of 3 salary surveys, and that is done by Department Administration. They look at salary.com. That's the largest proprietary database of salaries. They look at the National Association of Compensation for State Government. There's about 40 or so, and we look at 5. When I say we, Department Administration, they look at 5 states. They look at Montana, of course, and they look at Idaho, North Dakota, South Dakota, and Wyoming to benchmark for salaries. And then the other one is Department of Labor. So that's 3 surveys that they look at.
Are any of those jobs in general, or are they all pretty much focused on government?
The Department of Labor for the feds, that one is predominantly government. It also has private sector, but that's probably the largest one they look at.
So it's mainly government.
Yes, but also including private sector.
Some private sector.
Mm-hmm.
Commissioner Welborn.
Thank you, Mr. President. Tina, right before you moved in here, it was pointed out, and if you would clarify that this analysis was from 2024, is that correct?
Thank you, Commissioner Welborn. The Department of Administration, they run these surveys on an even year, and they have to do that before June 30th. So this is the most recent now that captures 2024.
Okay, thank you. Do you know, is there any kind of an inflation mechanism that is factored into this that would show these numbers in real time as we look at them? Or, I mean, is there any function like that Department of Admin does when they're putting these numbers together?
That's a good question, Commissioner Welborn. And I think the inflation is probably seen in the survey itself because there's so much higher increases in salaries across the board. So I do believe that's captured.
Okay, and Mr. President, if I could, this is more for an educational component for a neophyte like myself. But when, for instance, when the legislature approves a new pay plan, and it might be like a 2 and a 2, which would be a 2% increase and a 2% inflationary factor. Does that cover state government as a whole, or is that by agency? I mean, do you know if when things like that happen, does it also find its way into our agency, or are things done a little bit differently? I'm just curious.
Thank you for the question, Commissioner Welborn. The statutory pay increases, those are separate from the actual market analysis. So it's only for current employees that receive the statutory pay increases.
Okay.
And then we, as an agency, we're not appropriated for the market analysis. So we don't get an additional appropriation for the market analysis that's completed.
Thank you. That answers my question.
You're welcome.
Are there any further questions of either staff member? Seeing none, I'd like to make a motion that we accept the revision to the internal policy manual and Appendix 1 to reflect 2024 market analysis rates. All those in favor say aye. Yep, need a second.
I would second.
Got a race for second. Having a motion and a second.
Question.
Is there any further discussion? Question's been called. All those in favor say aye.
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 And those opposed, same sign. 5 zeros. It passes. Next, we have revision the internal policy manual, aka IPM acknowledgement form to consider updating Appendix 1, internal policy manual acknowledgement form of the internal policy manual. Staff.
Thank you, Mr. President. The purpose of this work session is to consider another revision to the IPM, this one being specifically the IPM acknowledgement form. I did include both versions, both the original and the edited version for your review. Of note, there was some discussion among staff that there were a few key things that were missing from the original acknowledgement form. To highlight those very quickly, there was no discussion about the IPM being subject to change, so the new version will include that. There is also verbiage in there to show that any changes will be communicated through official channels and from notices from the Department Human Resource Officer, and further that this IPM is not a contract and it's not intended to create contractual obligations of any kind. So those were the highlights from the changes, but you're more than welcome to take a moment to review the additional changes reflected in that new proposed form. Pending any questions.
Does anybody need a moment to review this? Seeing none, is there any discussion? About to. Is there a motion to adopt new policy manual acknowledgement form? Sure.
Thank you, Mr. President. I'll make a motion to support staff recommendations.
We have a motion. Is there a second?
I'll second.
A motion and a second. Is there any discussion?
One thing, Mr. President,
Yes.
is Chief Legal in the room, Lucas?
He's coming to a microphone.
Okay, great. This question goes to kind of the legal disclaimer that is the final sentence of this form. And I had a question about this that I asked our chief legal a few weeks ago. And this is, and he can explain this, I think, better than I could. But Lucas, can you explain why that language is in there and what it means?
Yes, Mr. President and Vice President, is my microphone on? Am I coming through?
Yes, you are.
Yes, so the last sentence of the IPM acknowledgement form, which is the provision that your executive director just discussed, understanding that the IPM is not an employment contract and is not intended to create contractual obligations of any time, is a fairly boilerplate provision in an acknowledgement form associated with an employee handbook. The idea here is that you, by acknowledging the existence of the IPM by the act of the agency providing the IPM to the employee, you're not changing the standard terms of whatever employment contract already exists between the employer and the employee. It's not a promise of continuing employment as long as they abide by the terms of the IPM. Rather, we fall back on all the standard state of Montana policies with respect to the employment relationship between the state of Montana and state employees, and Montana's laws on the employee-employer relationship.
Thank you for the clarification on that.
So I overall agree with the principles lined out in the IPM and the reasons for the development of the IPM. The development of the IPM involved extensive quality work to, delivered a quality product. The principles in the IPM are overall exemplary. I'm fully knowledgeable of the content, and I was involved in the votes on the various tranches. I do not agree with making people sign a signature page that says they will abide. This concept is reminiscent of loyalty oaths required by historic despotic government regimes that I have studied. My constituents hired me, they voted me in, and they pay my salary through their taxes. They expect me to behave honorably in my job and in my oath to the Constitution. I work for them and not a bureaucracy. I voluntarily carry out my job duties honorably. Some things are negotiable, principles are not. I cannot and will not vote for this. Signing it would be a conflict of interest with my constituents.
Thank you for that. Are there any other comments? I have a couple. Oh, wait a minute. I saw Lucas look like he was going to throw something in.
Yeah, if I may,
Please,
Mr. President,
please do.
I would just like to highlight that one of the reasons for this revision to the acknowledgement form is to address the concern that Commissioner Bukacek just mentioned. It no longer says, for example, that I agree to follow all of the elements of the internal policy manual. The purpose of this form is really just to acknowledge that you have been made aware of it. You have received it. It's not that abide by language anymore in this revised acknowledgement form.
So one of the ones that I have marked as revised still has that in there. It says in accordance with the undersigned acknowledged receipt of the IPM and agrees to abide by that. That says revised. That indicates it's the revised edition. So if all we're expected to sign is this third page, see there's an original, there's a revised, and then there's an appendix. And the revised, at least what I have marked as revised, still says receipt and agrees to abide by it.
Commissioner Bukacek, I believe the one marked revised was the original one, just through the nature of how that was printed out.
So all we're expected to sign is this one?
Yes, that's correct.
Fantastic. I'll be a yes vote. May I have just a minute to read it again? To make sure.
Hey, can you tell us, I'm looking at Appendix 1. Is that the correct one?
Mr. President, yeah, it is. It is if it has the blue banner up above or in between the two PSC logos, it says Appendix 1. That, at least in the electronic version, is reflective of the revised version of the policy. So it's the last one, hopefully, that appears in your packet for this work session.
Okay.
So this one that says revised is not it. It's only this appendix. So I got to wax philosophical, but.
Yeah. Again, Mr. President and Commissioner Bukacek, I just looking at your binder from over here, I can see the confusion there. It's just printed double-sided, so it's meant to be, yes, yeah, exactly.
And a fine job you did. Okay, not waxing philosophical. In the second paragraph, it says, I understand that questions about the IPM may be directed to my supervisor, the executive director, or the Department of Human Resources as appropriate. I think that's fine. But to say that you can't ask a question so far as interpretation to a specific event, to a commissioner, to take it to a review from administrative procedures is wrong. If somebody has a complaint about how the IPM is being interpreted, and heaven forbid it should be with their supervisor or the executive director or our resource officer, human resource officer, too bad that's where it stops. Maybe they don't want to discuss it. There has to be, at a minimum, I believe, the ability to have it laid out to, or resource officer as possible. Other avenues may include talking to a commissioner, the president of the commission, vice president of the commission, seek legal counsel, whatever they want to do. It doesn't stop with one person. How dangerous is it to have one person? Big money, far above executive director. A chief legal was relieved of position. A lot of money got paid because it wasn't done properly. There needs to be more than one head, more than one set of eyes, more than one opinion. And it should be open to all. We had other discussions with the commissioner and wound up paying big money on that one. To have those discussions stop with the resource officer or the ED or a supervisor, because that's what this says, limits the ability to seek redress. We should never do that. It should be very clear. You can take it clear, to administrative review, and if you don't like that, you can go to court. It doesn't, the conversation does not stop there. Skip everybody else and then go to there. Our object, our goal, I believe, should be to find compliance because we've reached an understanding and agreement, not because we fought it down to the last nth. So I don't like that.
Can you summarize that, please, sir?
Yes, I don't like it. That I don't like the last sentence in the second paragraph, that it may be directed to, and there's a finite list. If somebody wants to take it to a commissioner, if they want to take it to the vice president because they think they'll understand it, if they want to take it to the president, they should not be stopped by an interpretation of an internal policy manual.
Mr. President, may I address that?
Please.
I think that what you have here is kind of a standard use of chain of command. So if somebody has, this is a personnel document, a human resources document. So if somebody in the agency has a question about it, they ought to talk through the chain of command to the people that would be knowledgeable. And those people then would be responsible for raising issues up the chain all the way to the commission if necessary. If somebody really has a problem with something that's going on in the agency or with a conversation, say it gets stopped or shut down, there's also a grievance policy that's in our policies and also provided a grievance process through state law. So nothing ever stops the way you're describing. It's just routing things through a appropriate chain of command initially to make sure that people are getting the right information back and not individual interpretations from various people who may or may not have the expertise in that particular subject matter.
I would agree with that. I don't know that any supervisor currently hired, someday to be hired, would have that's expertise. I believe our current executive director just might. I don't know that the next one will. I do not know that I am pretty sure, I've known Tina Lumazin for some time. She knows her stuff. I don't know about the next one.
Well, I think the idea is they need,
excuse
I'm
me,
sorry.
to say that you can find an exception to this on another page or in state law or in judicial rulings, I think ignores the fact that I think it should be plainly put in here. We're forming a list. Let's complete the list. Let's make it clear. Somebody who's a second year working here has a big problem. In their mind, it's a big problem. And their problem is with the executive director, and they really don't want to talk to that executive director. We've had several in a very short period of time. They say, well, fine, you can talk to a commissioner, and the commissioner can put it on a work session. I don't think is misuse of ink on a page.
Well, it's meant to use HR procedures that help make sure that things are addressed through proper channels. I think it's actually important that we have those proper channels to follow so people know what they are, and those channels do include finding out information. If somebody isn't able to address it, they know where to go, and that's why we have professional staff at the agency to assist with human resource matters. It's why we have legal counsel. It's why we have our executive director and things like that. So, I mean, it's just part of the order that we've tried to bring to the agency because, as you may be aware, it was there was a lot of problems at the agency prior to the manual going into effect, and a lot of disorder, a lot of chaos, and a lot of strife. And this is a pretty minor part of trying to resolve that, but it's a reinforcement that there is a chain of command, and someone who has a question about something should know what that chain of command is. It says may ask. It doesn't say cannot talk to anybody. I mean, it's not that kind of a document, but it's just giving advice that this is, this would be the recommended route to go with your question.
I think you're right. I think legal should be included in my list. Moving on.
Mr. President?
Yes.
I looked over yours to see if we had the same thing, and we did, and you had underlined the same thing. It says, I understand that questions about the IPM may be directed. It's not saying you can only talk to these people, you can't talk to anybody else. So I don't understand how what you're saying is relevant to this document.
It's relevant because it says you may ask these people.
It says you may be directed to. It doesn't say that you can't talk to anybody else.
And I'm trying to make sure that they understand, that the layperson would understand that this list
I
is
think
not-
maybe is understandable by most
Right.
people.
Thank you for that. Secondly, and I've been admonished on this part of the discussion that employees' names, anybody's names can't be used. But this is the internal policy manual. At least one case is currently being directed to outside to come in and interpret actions under this manual. The third party. Can't find any precedent in here that says that we won't handle internal matters internally. What is professional conduct? What is dress code? What is, appropriate this, that, and the other thing does not require. I've seen this before on a previous commission where outside review was actually intended to silence people to make sure that they did not want to be. I've seen legal that was going away to work for those that were regulated. It appeared as though, in one case very, very plainly, that they were making motions that would find favor with a new employer. As to how far back that went before the application, I have no idea. But unless there's something in the manual that describes under what conditions third party would be brought forward, as opposed to, well, in this case, in what case? For example, let's assume that we used a Department of Labor person. This is purely hypothetical person to take a look at a grievance. We just spent 4 months trying to stay away from the governor appointing commissioners. That person could easily, not necessarily this governor or any governor, could say, build a case, well, I want to see some bad headlines. I want to make sure that people understand. That should never be the case. If it's going to be an independent review, it should be because for a reason. A stated reason that matches the policy and not on an individual case.
I'm sorry, Mr. President. Is this pertaining to the?
It does. It's what has to go into the manual before we will limit it only to these people. And then those people in a closed meeting decide they're going to take it outside of that. That's very much a matter of this.
Did you have a question that we could answer?
No, I have a statement that people on this list should never meet secretly to decide something will go outside of this commission and place anybody at risk. There should be a well-defined policy. If it's ever going to happen, that a third party should determine what happens inside our own internal policy manual. If somebody's breaking the law, charge them. If they're not, if it's a matter of dress code, if it's a matter of attitude, it's a matter of somebody dropped, got into a hot discussion and dropped the F-bomb out there, that's internal. It's not external. That's my point.
May I ask a question of staff? I'm not sure which staff person, but is there something in state policy that talks about when you can go to outside? Seems like it would be a basic policy that agencies are allowed to go for outside review. And so I'm thinking there's probably something in state policy on that, in that regard, that might help President Molnar and us understand that.
I think we're way, Mr. President, I think we're way off the motion here. The motion is to amend this form with this language that's before the commission. It's a yes or no vote.
That would be incorrect. This is a question of, do we adopt this policy? And I'm saying it is not fleshed out at all, to a point that all staff could feel free that they will not be up for third-party review, having no idea of any biases brought forward or why it was put out there.
This is the appendix to a policy that's already adopted and enacted by the commission. This is a form that's been, that is with an amendment that's proposed on the form. It's not an amendment to any other part of the manual.
As in the first part of this discussion, the listing, to be told, oh, well, you can go somewhere else and find some sort of redress. Put it here. I don't think that's asking a lot. So I will make an alternative motion that we not pass, that this motion not go forward, but rather this policy acknowledgement form be sent back to address the issues I just raised. Is there a second?
I'll second.
Is there any discussion?
Is my question appropriate now, Vice President Fielder?
That's up to the president, up to the chair.
I have no idea what your question is, but would it have to do with the amended motion before us?
Yes.
Then please state it.
Is there somewhere else in the state policy that lines out when outside review is appropriate?
Mr. President, Commissioner Bukacek, yes. So the Commission's Code of Conduct policy adopts the state of Montana's policy on investigating complaints of harassment, discrimination, or retaliation. And so there are a whole set of administrative rules that the Commission has adopted, including Montana Administrative Rule 2.21.4020, which discusses the process of investigating a complaint. And in that rule, part one of that rule discusses how the EEO officer, the ADA coordinator, or another representative chosen by management shall begin an investigation upon receiving a complaint. So it does leave discretion to agency management to select an investigator.
Okay, thank you.
I'm not going to be, because of the confidentiality, as one must be maintained. I'm not going to ask if that was in this case that I'm concerned about. Having not reviewed all those, what you just said did not include internal policies that it can simply deviate as they see fit without any clear policy. I'm saying we don't have a clear policy as to what gets allocated to that and what's handled internally to make sure that all people are treated equally.
Mr. President, if I may, on that point, there is an internal policy that does govern the ability to go external if needed, and that is encapsulated in the response team section of the IPM. That clearly outlines if there are conflicts of interest within an internal investigation, the response team has the ability to vote for an external party to come in and take a look. And so that may be what you're referring to. I hope that answers your question.
I don't think anything can answer the question. I'm not seeing it on this form. I don't know that it's been followed, and I don't like arbitrary and capricious. I would like to see it absolutely positively nailed down as to at what point the internal policies will be reviewed by an outside source.
Mr. President,
We handle
As
hundreds
the-
of millions of dollars at a time. The possibilities for pressure to force somebody to leave so that another one can be appointed are tremendous. This is either hammered down or it's not hammered down. And near as I can tell, it's not hammered down. Say that, well, you can do this and we can do that. Who is we and when do they do it? That's the question.
The answer to that question, Mr. President, is within the IPM. As I mentioned, I think President Fielder mentioned previously that due to some misconduct in the past, there was a great effort to put together these rules in the IPM to allow a very clear and accountable way to deal with complaints that came forward. And as I mentioned, one of the avenues for that outlined in our internal policies is to form our response team. And the response team does have the capability via our internal policies to make those decisions, whether it's appropriate to handle internally or externally.
I don't understand your reluctance to say, okay, we can set this aside, take a look, and make sure that all concerns are there. There's no reason to do this today.
Well, Mr. President, if I may, this question about the IPM acknowledgement form has been lingering now for close to 6 months in the agency, and staff worked on putting together a proposed amendment to this form that they felt addressed their concerns. So I believe that this is staff driven to address the concerns they had. And in dealing with specifically with the IPM acknowledgement form. And so this motion today to adopt this form, as I tried to explain earlier, is very narrow to this particular form. It's not expanded into the rest of the manual. It's an acknowledgement form that you receive the manual. Basically that. So basically nobody can say, well, I never got it. I didn't know we had a document that I was supposed to follow. I didn't know about this information. It's incumbent upon management to make sure that it's distributed to commissioners and staff, and it's incumbent upon those who receive it to acknowledge that they've received it. So that's what this form is attempting to do.
I
And
understand.
I do believe if we pass it today, it will satisfy staff concerns. At least that's the impression I've received from our management staff. And if there are other matters with other parts of the manual that you or anyone else would like to take up, we're free to do that through the amendment process, where the amendments are put together and circulated 30 days in advance, just like this one was, and we can hash those things out. But I don't think it would be a good idea to delay passage of this form, given the amount of time that it's been lingering. And I know the auditors are looking at us in terms of how we're doing and implementing our policies. And I actually have to answer to the auditor regarding our performance. And one of the specific issues they brought up was our conduct and our code of conduct. And I have to answer to them later this month. So I'd really recommend that we get this little piece resolved so we can then move on and address other pieces if we need to.
Well, if you have to tell them that we're taking a second look at it, that's fine with me.
Mr.
Yeah.
President, may I ask one more question?
One more.
Either Vice President Fielder or one of the staff. So to hammer it down, as President Molinar talked about, I mean, every case where there's some kind of a problem, it's going to be different. It's going to have to be taken individually. I'm thinking there isn't a way to hammer everything down to cover every possible complaint, allegation. Do you agree?
Mr. President, Commissioner Bukacek, for my part, I think that's correct. Every complaint, the nature of the complaint, will need to be evaluated based on the circumstances surrounding that complaint. And that is, I think, the purpose of the response team within the Code of Conduct policy, is to have that tailored sort of response. That said, all investigations must still comply with the Montana administrative rules on conducting investigations. That is clear from the Commission's policy. That is also clear from the policy of the state of Montana. So we still must be consistent with those general guidelines of process, but the particular course of any given complaint, that will depend on circumstances.
Thank you.
Commissioner Wellborn.
Thank you, Mr. Chairman. I think this would probably also be for Lucas, but I think you probably partly answered my question through Commissioner Bukasek's round of questions, but I just want to make sure that I'm crystal clear. So whether it's the grievance component that Vice President Fielder was talking about, or whatever the case may be, what I'm hearing is there is an instrument or instruments available within the IPM that would cover issues beyond what this acknowledgement form, whether it's listed on here or not. I mean, that's, I guess, the way I understand it. This acknowledgement form is just saying, yes, I've read the manual, but it's the manual itself that creates the clarity for anything that may or may not be listed on this, but there's still an avenue forward regardless of what may come our way to. There's a system in place to cover the concerns that the president has or beyond. Is that a fair assessment?
Mr. President and Commissioner Wellborn, yes, I would note that the second paragraph of the acknowledgement form revised begins with just, I understand it is my responsibility to read the IPM and familiarize myself with the policies contained therein. So it's not even a document that says you have to represent that you have read it all in its entirety. Just you acknowledge that it is your responsibility to read it, familiarize yourself with its policies. So to step back from that, though, to your larger question, yes, the acknowledgement form is not meant to be a vehicle where policies are repeated. It's meant to be an acknowledgement that you've been given the opportunity to see the form, to review the policies. That is, you've had the opportunity to review them. You've been notified of people who can answer questions if you have them as you go. And it's really just meant to be an acknowledgement and not necessarily a recitation or an agreement to abide by every particular of the policy manual.
Thank you.
If I
So
might
with
have been asked for the
that-
question. Oh, my God. Yes, please.
I just want to make sure we know where we're at. So we're still on your substitute motion to basically table this even with that explanation. Are you going to keep that motion live and have us vote that up or down, or are you going to withdraw your motion?
I'm not going to withdraw my motion.
Okay, just wanted to be sure where we're at.
Yes, without going into any real specific. In the case that I'm thinking about, no names can be given, that's fine. When an issue is turned over for third-party review, but the person is being reviewed is not told what the complaint is or who made it, I don't think any of the assertions that were just made are in any way valid. There needs to be specificity in this, not just, oh, well, they can do it because somebody else said they can do it. This is our internal policy manual. This is not a general case. This goes to our policies. And our policy should always protect our employees. They should know in very quick order who filed the complaint, what the complaint was, and they should be able to address it. Our policy manual says that there should be discussion, that they should be able to talk to the person. What I'm talking about has been totally subverted, and no employee here should have to face that. I will stand for due process. I will vote for my amendment. If it does not pass, I will vote against this, period. And I'll not sign it. So if there's no further discussion, all those in favor of setting this aside and working on it to try to bring the clarity that I've requested, say aye. Aye.
Aye.
Not hearing okay, hearing first and second. Is there any further discussion?
Are we back on the original motion now? Because your motion failed?
No, because we had two. Therefore, we open it up for discussion. Then we'll vote. Is there any? I can't believe there'd be a lot, but is
I
there?
think we just voted on your motion and I didn't hear a majority vote, so I believe that motion failed.
Okay, you're right. Okay, that having failed, we return to the original motion. Is
Okay.
there any further discussion on the original motion?
I'm going to support the original motion. I think we need to get this settled, and I think there's ways to address the other concerns that you raised outside of, entangling this form in that process.
I would have to agree with you. I'd hate to see a form entangled. Sure.
And I will also be supporting the motion. And Mr. President, I wholeheartedly understand and know that it's with the best of intentions, where your concerns are coming from. I do believe that there are other avenues and another time and place to have that discussion. And I would certainly commit to sit down and gather your input on doing something like that. But, in the appropriate part of the manual to kind of drill down on where you're going. And, but in the meantime, I'm going to be supporting this as written today, Mr. President.
Is there further discussion? Seeing none, all those in favor of the motion will say aye.
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 Those opposed? Aye.
So the
Uh,
motion
passes
carries
4-1.
4-1. Was that what I heard?
It is.
Thank you.
And item number 3, Northwestern Energy. And Northwestern Energy's application for 2025 propane supply cost account balance and rate adjustment for Townsend Power Supply to consider issuing an interim order approving Northwestern's requested supply rate adjustments for Townsend propane. Staff.
Yes, good afternoon, President Molnar, Vice President Fielder, and Commissioners. On April 30th, 2025, Northwestern Energy filed their annual Townsend propane rate adjustment application in docket 2025-05032. Northwestern's applicable tariff allows it to track propane costs against revenues for a June 1st through May 31st tracking year, and also to true up any over or under collected costs in this annual filing. In its application, Northwestern seeks commission approval to recover an undercollected balance of $1,446 and to increase its current supply rates to reflect its current supply contract with Midstream Energy Partners, LLC, the winning bidder through a competitive RFP process. Proposed rates also reflect costs associated with plant usage and carrying costs. If approved, the rate associated with the undercollection as well as the new supply rate taken together would result in a monthly bill increase for a typical residential customer as follows. $1.94, which is a 2.3% increase for the months of June through September. A $2.07 increase, which is a 2.1% increase for the months of October through March. And a 71% increase, which reflects a 0.8% increase for the months of April through May. Staff recommends approval of this request on an interim basis for propane service provided on and after July 1st, 2025, and we're available for any questions that you may have.
Are there any questions from commissioners? Seeing none, do I hear a motion?
I move to approve the requested rate adjustments on an interim basis beginning July 1st, 2025, to issue the draft order as the Commissioner's final interim order and to authorize staff to make non-substantive edits as needed.
You heard the motion. Is there a second?
I'll second the motion.
I was just going to say, let the people in Townsend freeze to death. So we have a motion, we have a second. Is there any discussion? Saying, okay, we have Commissioner Bukacek.
So the draft order references the applicable tariff that allows tracked propane costs, true-ups in annual filings, and amortization based on forecasted sales. Based on the application from Northwestern that included fact sheets and tables of tracker period summaries, the requested propane supply rate adjustment is reasonable and just for interim purposes. And as line 19 of our order states, nothing in this interim order precludes the Commission from adopting a subsequent interim order or final order that changes or reverses this interim order. This interim order shall not constitute the Commission's final endorsement or approval of any issues, calculations, or methodologies approved herein, which is typical for the interim rates.
Is there further discussion on the motion? Seeing none, all those in favor say aye.
Aye.
Those opposed, same sign.
No.
We have one yes, I'm sorry, 3 yeses, 4 yeses, and 1 no. Motion carries 4-1. The next business meeting is scheduled for Tuesday, July 1, 2025. Seeing no further business to come before the Commission, for the record, the time is 2:22 p.m. and the date is June 24th, 2025. This meeting is adjourned.